Family disputes can make us feel isolated and vulnerable. Maybe you're going through a divorce or a legal dispute about your kids. Perhaps you've spent hours on Google or have even posted anonymously on Facebook to see what others have to say. But are you getting the actual information and support that you're looking for? Our podcast, Legal Lounge, aims to dispel misinformation and downright bad legal information to empower anyone with questions about their family, their children, their finances, their marriage, and the law. As a team focused exclusively on family law matters, we aim to help listeners not only with the information they need, but also with the hope that their situation has a solution. Short disclaimer, please note this podcast is for educational purposes only, and the information should not be relied upon as legal advice or for legal purposes. Welcome back to the Legal Lounge. We are here today with attorney Deb Dilman with the Modern Legal Team. Hey, Deb, welcome back.
Hi, thanks for having me back.
Today's episode is going to be on collaborative law, negotiation, mediation, and all of those out-of-court forms of relief for those going through a family law dispute. And I know, because I come to you running with questions, you know everything when it comes to collaborative law. So can you tell the listener a little bit more of what is collaborative law? What does it mean to be collaborative and so forth?
I can, but before I do that, I want to say that in my world, so what you're referring to, they call commonly alternative dispute resolution. And I would like to get rid of the word alternative and just call it dispute resolution so that people start thinking about collaborative and mediation before they think about litigation.
I love that.
So that's one of my goals.
I support
if
that.
we can do that. Yeah, absolutely. But collaborative law, so collaborative law in the state of North Carolina is a thing. It is not a word that's to be used lightly. We call it collaborative with a big C. It is a process by which it's codified by statute. And there are certain processes that need to happen through the collaborative process in order for it to be considered collaborative. From a layperson's perspective, what that means is you are a couple who wants to uncouple with little acrimony, and they want to do it in a way that is honest, respectful, and not adversarial with the other party. So you are having meetings, joint meetings, where you are disclosing things to one another, whether it's emotional things or legal issues documents, where you're not hiding things. You're not hiding the ball to use it as a weapon later, which happens so much in litigation. But it is a process. They sign an agreement that says we're going to treat each other with truth, respect, and we're going to get through this as reasonably as possible. And they sign an agreement that says, I'm not going to go to litigation.
I love that you pointed out that it's an actual statute.
Mm-hmm.
So if you have your Google out, you can literally Google North Carolina statute collaborative law.
Yep.
And in that statute, there is a list of requirements that us as legal professionals and attorneys have to follow to truly follow that statutory collaborative law process.
That's right.
And that includes the reference to that agreement, right?
That's right. And there's two collaborative statutes. There's civil and then there's family law, which are different but similar,
Mm-hmm.
right? So in our world, it is the family law statute that we're referring to. And there is, in the statute, it says that in order for it to be considered collaborative, you have to sign an agreement. And there are lots of people that practice cooperatively,
Mm-hmm.
but I would say not collaboratively because they've not signed that particular agreement. But that agreement protects everybody from litigation and disclosing information that you wouldn't know if you were in a pure litigation case.
That's a good point. And let's kind of go into that agreement a little further. Because my understanding of the statute, granted, you do a lot more collaborative law than me. I tend to be in a courtroom, I admit. And in the collaborative agreement, it specifically states that the parties are agreeing to the collaborative process such that the attorneys that they retain for that process cannot represent them in a litigation proceeding should the collaborative law process fail.
That's right. And don't be scared by that. Lots of
Mhm.
people are scared. Lots of attorneys are scared about that because they're afraid they're going to lose a case if it doesn't get settled in the collaborative process, and they're going to have to give that case up. And while it's an incentive, I look at it as an incentive. It incentivizes people to settle cases outside of litigation so that they don't have to start over. And I haven't looked at current research, as in like 2025 research, but the previous research has shown that 95% of the cases that sign agreements where attorneys are precluded from representing you later if you impasse, 95% of those cases get settled. You're not going to see that anywhere else.
That's huge.
It's huge.
Yeah.
And so there's no reason to be, in my opinion, if you are confident as an attorney and you've got control over your client that you're working with and the client is motivated to get things resolved in an amicable way, there's no reason to be afraid of signing that agreement because you're going to get it settled.
Yeah.
And in Mecklenburg County specifically, I don't remember what the statute says about this, but we've made a conscious effort to say if we reach an impasse, we'll go to mediation. We don't go to arbitration because arbitration, someone is calling balls and strikes.
Mm-hmm.
And the whole idea of collaborative work or mediation work is you let the clients make the decision on what happens. There's nobody calling balls and strikes. So if you reach an impasse in the collaborative process, you still have an opportunity to use a mediator as a fifth person to help you resolve whatever the impasse is.
And that's huge. So a clarification here. Litigation is the process by which someone files a lawsuit if they have a legal dispute. And essentially what that turns into is a battle in a courtroom, some punching, some mudslinging. And yes, we call it sometimes a circus where attorneys are trained to put on a good show. But at the end of the day, the clients, the attorneys do not have any control over the outcome. The judge does. And that thereby takes that control and influence, true influence and decision-making authority out of a parent's hands, out of a spouse's hands, and into a stranger's hands. That stranger, great, they went to law school, great, they got elected on the bench, at least here in North Carolina, great, they may know a little bit about family law, but they know very little about your family situation. Put that in comparison to the collaborative law process and the mediation process, where actually that final decision-making authority rests with the parties, not the stranger. I think that's huge because a lot of people are like, well, how can I maintain some type of influence and control over my situation? And then in the second sentence, they're like, well, I want my day in court. And I'm like, well, those are two things that don't work together at all.
That's all correct. And I'd take that one step further.
Yeah.
That the other thing that collaborative does, and even mediation to a lesser degree, but collaborative, it allows you to come out of the process whole. You move the process at the pace of the slowest person. So if someone's taking a little bit of time because there's some emotional pieces that they're working through, we just let that happen. But you come out whole. In litigation, the only people that win in litigation are the attorneys. The families do not win. Someone will come out of that courtroom feeling they won and they have all the power, and the other one will come out of that courtroom feeling they lost and they have no power anymore. And so your family can become even worse off after litigation because everybody continues fighting. Whereas in the collaborative process, the whole idea is you work together, you find reasonable solutions that will work and alleviate the fears that everybody's having, and the family comes out relieved and whole, and they can just move on with that new relationship, whatever that is.
And I would add a caveat. Is that person walking out of a courtroom thinking they've won, that is temporary, first off. And second off, it's an illusion.
Correct.
Yeah, because they may feel, oh yeah, I got what I asked for. And then when they reflect, oh, this is what I've asked for. I've asked to, in a way, screw over the person that I may have built a home with, may have had children with. And really that adversarial system is not conducive to your point, creating individuals a next chapter, a new place to start from after they separate and divorce.
And if you have kids, you should want the other parent to be in a good place when you're done.
Yep.
You should want that parent to not be worried about how am I going to pay bills? How am I going to put food on the table for our collective children? Everybody should want that. And the collaborative process allows you to do that. Or in litigation, you're just sitting there and someone in a black robe is telling you what's going to happen.
Yeah.
That's it.
That's huge.
It's terrible.
Yeah. Building relationships is a natural part of life. But how does the law affect those relationships? Do you want to marry your significant other? but have cold feet from the many divorce horror stories out there? Are you preparing for a custody battle against your ex? That is where Modern Legal comes in. We offer education and knowledge about the law when it affects the relationships near and dear to your heart. To learn more about how family law affects your family, book a consultation with an attorney of our Modern Legal team by visiting our website, emailing us, or calling us at 704-286-6302. Check out the information about Modern Legal Services at modernlegalnc.com. And let's go one step further. The collaborative law process not only has that agreement and not only has certain obligations of legal representation and attorneys and the parties, but you can also bring in third-party professionals that can help everyone through the entire collaborative law process.
Yeah, in the pure model, pure collaborative, it's not you can also maybe bring somebody in. In the pure model, you would always have a divorce coach. Like you would start your case with a divorce coach. The divorce coach should be the person facilitating all of the meetings, and that person is usually a mental health professional with some specific designations and has gone through the training, even though they're not working in a therapeutic role. They're working in a coaching role. But those individuals, especially in cases where there's children involved, they will help the parents get to the place where they can switch that relationship of their marriage to the relationship of raising children together, right? It becomes a business relationship now. So in the pure model, there would be a divorce coach. In some states, there's two, one for each parent. We don't do that here. In the olden days, when the collaborative laws were first codified, everybody thought you had to have an outside professional, divorce coach, a neutral financial person, and a neutral child behavioral specialist. That had to be part of the team. Over the years, we've learned that we don't need to have all of that in our professional team. We bring in folks as we need them. But I believe the model of having a divorce coach in every case is the appropriate model. And not everybody agrees with me. That's okay.
That's okay.
That's
Yeah.
I'm okay with that. I think that the divorce coaches, because they are mental health professionals, they deal with the emotional piece that attorneys struggle with.
Yeah.
Even though we call ourselves, couch therapists, we're not really very good at it. And that's not what we're trained to do.
Yeah.
And I don't like being in that position. I'd rather someone who's skilled at it deal with it. And people are like, well, that's going to double the cost. Well, it's not if you do it right.
Yeah.
You bring in a divorce coach if you know that there's emotional issues going on. And then the divorce coach works with families for however long it takes, the couple. And then you bring in the attorneys. But it's not all of us doing work at the same time.
Yeah.
Eventually, there will be some work that has to be done at the same time. But once you settle the emotions, you can focus on the legal. I don't think you can effectively do that the other way around. I don't think you can deal with the legal without resolving the emotional piece of separation.
Or at least resolving the portion of the emotional pieces that are influencing and impacting your decision-making authority.
Which is almost everything.
Yeah. And there is an emotional component to every separation and divorce.
2 cases to separation, emotional and legal. Every single one.
Every single one.
Yep.
And to your point, there has to be due nod and consideration to that emotional piece, because I know you are not the only one, and I'm sure every attorney at a firm would agree that there have been calls where we're talking to our clients about what we think is relatively straightforward legal issues, and we're giving them legal advice, but that legal advice is not being absorbed by our client because they may be crying. They may be thinking, oh, I'm worried about my child and their grades in school, which, yes, we attorneys care about the children's grades, don't get me wrong. But honestly, there's nothing legally speaking that I can necessarily do here in the now to change your child's grade from an F to an A, right?
Yeah.
But there are things that we can do from the legal custody perspective. And if my client is emotionally wrapped up in that concern, I can't get them to that next step to do what's best for their legal situation.
Nor should you try.
Exactly.
Yeah.
Exactly.
I mean, you just really should not push that if they're not ready to hear it.
Yeah. And if they're not ready to hear it, then there should always be some type of tool or mechanism or person that we can involve to help our clients get through that process. And I feel like that specifically, that reality falls on deaf ears in the litigation process, especially because once the ball gets rolling in a court case that's been filed with the courts, judges will institute deadlines and you got to meet them. and there will be a trial set, and you got to go to trial. You can only get so many continuances. You can only delay things for so long. And if in that time you haven't resolved certain issues like those emotional issues, you're going to be in a courtroom, possibly having an out of body experience, being told what's happening with your most intimate affairs and your children, and you're not going to realize what's going on.
That's right. That's right. Until after the fact, and it's too
Mhm.
late then.
And it's too late then.
Yep.
Yep. And we've seen that a lot too as
Yeah, we
attorneys.
have. I
Yeah.
mean, we're all trained in law school to be litigators. It,
Mhm.
it doesn't change. I mean, there's collaborative cases out there, there's conflict resolution classes, but at the end of the day, they train us to be litigators. And it
Mhm.
is extremely hard for lawyers to sit on their hands and listen to someone who's having an emotional meltdown.
Mhm.
It's just really, really hard. And it's a shame. We need to be better at doing that. We need to be trained as students to deal in empathy
Mhm.
and to deal with conflict resolution in a very, very different way.
Yeah. And emotional intelligence.
And emotional intelligence.
Yeah.
Absolutely.
Yeah.
Yes.
Agreed.
Yep.
And so explain to the, average listener, and I know every case is different,
Mhm.
but what does the collaborative law process look like from start to end?
So the process itself, like I said earlier, we move at the pace of the slowest person.
Mhm.
But the first thing, once we get past the emotional piece, so if we've got a couple that they have children and they're just having some issues managing the separation, they'll work with the divorce coach. And when the divorce coach thinks that they have that person or that couple at a place where they can move on, then we'll start dealing with the legal issues. And that would be a joint meeting. So, a joint meeting with the divorce coach, the two attorneys, the two clients. And we talk about, okay, what documents do we want to gather? What
Mhm.
financial documents do we need to deal with in your case? And it's different for everybody. So, we talk about those documents. We talk about a timeline of gathering those documents. We talk about whether or not there's a closely held business or several businesses, or maybe one of the clients is an attorney, a partner somewhere. So, they're getting money K1s from the partnership, they are an ownership. So we may want to bring in a financial neutral. And if we do that, then we let the financial neutral deal with, okay, what documents do I really need to have? But once those documents are all gathered and with whomever they need to be with, then we'll set another joint meeting. And there can be individual meetings in between,
Mhm.
but another joint meeting where we come together and we talk about those documents, make sure everybody understands them. If everybody does understand them, then we'll start talking about different options, just brainstorming options. What does it look like? What do you need? What's your biggest fear? Is it financial support on a monthly basis, or is it the asset distribution? How old are you? What are your plans for working? But all those options. And then we go away, and the attorney and client can talk more about what options work for you, what don't work for you, what do we want to throw out? Let's rate them, rank them. And then we'll have another meeting where we'll actually come back together as a group and we'll talk about, okay, these options work best for me. What options work best for you? And hopefully we're aligned.
Mhm.
And then we'll start putting together the options from there. If we're not aligned, then we'll start negotiating. Okay, we'll do that and we'll enter into a formal agreement. Sometimes we have signing parties
Mhm.
where we come back together as a group and we sign it as a group because we're done. Sometimes we don't need to do that, but we'll enter into a separation agreement, out of court document, legally binding. It's notarized by all parties, and then they're done until they're ready to file for divorce, which somebody can do whenever they want to.
And note to the listener, the divorce is a separate process from the
Yes.
collaborative law
Yes.
process.
Yes. And there's 3 times this week we've been asked about whether or not you can avoid the 12-month waiting period, and the grounds for avoiding that are very, very slim and probably not.
Yeah. Here in North Carolina, you got to wait the year.
Yeah.
Year and a day.
Unless you married your first cousin.
Yes.
But so that's the very simple way of talking about the collaborative process and what it looks like as you go through it. It's obviously more complicated than that, and it's individualized. But generally speaking, the joint meetings are designed to gather documents, talk about those, talk about options, and then come back and negotiate for a final agreement.
Let's say the parties have come very close on a lot of the pieces. And I'm just going to throw out the example of the financial pieces.
Mhm.
We've figured out who's getting what assets, who's getting what debts, and any type of family support, monthly payment per month. But what if, child custody specifically, which I feel in the litigation world really is our most litigated matter? What if child custody is just not able to be resolved in the collaborative law process? How is it handled when we're dealing with children in this type of circumstance?
Well, you can bring in a child behavioral specialist as a professional who will be a mental health professional, not to give therapy to anybody, but to actually be the voice of the children.
Mm.
So, depending on the age of the children, or if there are some specifics, maybe one child has special needs and we don't really know how deep those special needs go. So, we might want to bring in a child behavioral specialist just to meet with the kids, talk with the kids, see what's going on there. Those specialists can recommend some family therapy if it needs to happen, could recommend maybe some parent coaching if the kids are fine, but the parents just don't parent well together. But we can bring in another professional to work with us on that. All of my cases that have come through collaborative, we've never had issues with the children.
Really? Okay.
Yes. So I think what happens is most people that want to come through the collaborative process tend to understand, and I'm not really sure why. Like, I don't know if it's because they're more educated or if they're just more in tune with what's going on in society, but they seem to understand how horrible it is to throw kids and the family through a custody litigation case. So they usually come in and they're already somewhat aligned in parenting, and they've come up with a general idea of what they want the parenting schedule to look like. So I've not had a case where custody was the thing we couldn't resolve. It's usually the money.
Interesting. I find that fascinating.
Litigation, absolutely. It's almost all custody.
Yeah. Yeah. That recognition of the parents to realize that them working together is what is actually best for the children. That's huge.
Huge. You know, we forget the kids are really resilient, but they're only as resilient as we allow them to be. So the more that the parents can be aligned with one another, can be friendly to one another, not yelling at one another, arguing in front of the children, those kids will be fine. They just need to know that they're loved and you're not going to abandon them.
Well, Deb, thank you so much for joining us back on the Legal Lounge to give us a little bit more insight into the collaborative law process.
Welcome. The collaborative process is the way to go if you want to uncouple amicably.
Without that mudslinging.
That's right. Without the gloves.
Yeah.
All right.
Thanks, Deb.
Thank you. Thanks, Theresa.
And see you next time. Thank you for taking the time to listen to our discussion. To learn more about me and the Modern Legal team, go to our website, modernlegalnc.com, or check out the links in our show notes to follow us on Instagram, Facebook, LinkedIn, and YouTube. You can also call us at 704-286-6302. If you have been intrigued by the conversation and would like us to continue our discussions, please subscribe to the podcast and leave us a review. See you next time.